There is a memo dated 3 weeks ago, marked eyes only, Department of Homeland Security leadership. It contains 6 words that explain everything you are watching unfold right now across this country. I will tell you what those 6 words are, but first, you need to understand why they represent the most dangerous escalation of executive power since the War on Terror began. Subscribe to this channel right now, turn on notifications. What I am about to show you will be memory hold by morning if we do not make this go viral, because here is what is happening while you were focused on everything else. 23 states are preparing coordinated legal action. Republican governors held an emergency conference call last night that ended after midnight. Federal judges across 4 circuits are drafting emergency orders. And we are now 72 hours away from finding out whether the institutional guardrails of American democracy can actually hold against someone who has decided they simply do not apply to him. Monday morning, January 6th, 2025, 2:47 in the morning Eastern Time. While most Americans were asleep, the Department of Justice filed a motion in an immigration court in El Paso, Texas. The motion was 11 pages long. It requested something called expedited removal authority without judicial review. Now, if you are not an immigration attorney, that phrase probably means nothing to you. Let me tell you what it actually means. It means the government wants the power to deport people without a judge ever reviewing the case. No hearing, no appeal, no due process, just gone. Here is what makes this terrifying. That motion was not filed in just one court. It was filed simultaneously in 12 different district courts across the country. El Paso, Miami, Los Angeles, Phoenix, New York, all at the same time, all requesting the same unprecedented authority. And because it was filed during Martin Luther King Jr. weekend, when most legal scholars were not paying attention, it flew completely under the radar. I spoke with 3 constitutional law professors yesterday. All 3 said the same thing. If this gets approved, it is the end of due process as we know it. Keep watching. I will show you the receipts. Now, let me take you back in history because this is not the first time an American administration has tried something like this. February 19th, 1942. President Franklin Roosevelt signed Executive Order 9066. That order authorized the forced removal and incarceration of over 120,000 Japanese Americans. Most of them were United States citizens. They were rounded up. They were put in camps. They lost their homes, their businesses, their lives as they knew them. And here is the thing that matters most. That executive order did not require congressional approval. It did not require judicial review. It just happened. And for 3 years, nobody could challenge it in court. When the case finally reached the Supreme Court in 1944 in Korematsu versus United States, the court upheld it. They said the president had the authority to do this during wartime. That executive order began with a legal filing that nobody paid attention to, a bureaucratic motion buried in paperwork that seemed routine at the time. Sound familiar? The deportations did not start immediately. First came the legal framework. First came the quiet authorization. Then came the enforcement. That is the pattern. And we are watching it happen again right now in real time. So let me tell you what those 6 words in that memo are. The memo that went out to Department of Homeland Security leadership 3 weeks ago, the one marked eyes only, it says this: prioritize speed over procedural compliance, not balance speed and procedure, not expedite while maintaining rights. Over. That word is doing lethal work in that sentence. That is a direct order to ignore the law. That is an instruction to ICE agents and Border Patrol officers to stop worrying about whether what they are doing is legal and just do it fast. And I have the evidence. Leaked WhatsApp messages from ICE field directors discussing quota systems. Agents are now required to make 50 arrests per day, not 50 legitimate arrests, just 50 arrests. There is an internal complaint filed by an ICE union attorney. It is attached as Exhibit A to a lawsuit that was filed yesterday in federal court in California. The attorney says agents are being ordered to cut corners, skip verification, ignore procedural safeguards, all to hit numbers, all to satisfy a political mandate for speed over legality. Here is what nobody saw coming. The Republican Party is fracturing, but not where you think. Not in Congress, not among voters, among the lawyers, among the judges, among the people who actually understand what is happening to the legal system right now, and they are terrified. Let me show you what I mean. Judge James Ho, Fifth Circuit Court of Appeals, appointed by Donald Trump in 2018, one of the most conservative judges in the federal judiciary. Yesterday afternoon, he issued an emergency stay blocking the implementation of expedited removal in his circuit. Let me read you what he wrote. Quote, "This policy exceeds even wartime executive authority. The executive branch cannot unilaterally suspend habeas corpus protections established in our Constitution." End quote. A Trump-appointed judge just said Trump is going further than presidents have gone during actual wars. But it gets more remarkable. Jeff Sessions, remember him? Trump's first attorney general, the man who implemented the family separation policy, the man who was as hardline on immigration as anyone in that administration. Jeff Sessions filed an amicus brief on Tuesday in federal court calling this new policy, quote, "constitutionally suspect and procedurally reckless." When Jeff Sessions thinks you have gone too far on immigration enforcement, you have crossed a line that even authoritarians understand you should not cross. And it is not just judges. The Federalist Society held an emergency membership call on Sunday night. 14 members resigned during that call. These are the conservative legal elites who have spent 40 years building the judicial infrastructure that put Trump's judges on the bench in the first place. And they are walking away. One former Federalist Society board member told the Washington Post, quote, "We built a movement to protect constitutional limits on government power. What we are witnessing now is the opposite of everything we worked for. Now, let me tell you about the business community, because this is not just CEOs writing polite letters asking for de-escalation. This is active sabotage. Tech companies are refusing to provide data to ICE. Google, Microsoft, Amazon Web Services have all quietly stopped processing requests for user information related to immigration enforcement. Banks are declining to process ICE payments. Wells Fargo sent a memo to regional managers last week instructing them to, quote, exercise maximum discretion when evaluating transactions flagged as immigration-related. That is corporate speak for find a reason to say no. Major hotel chains are canceling Department of Homeland Security contracts. Marriott, Hilton, Hyatt. All three terminated agreements to house detained immigrants pending deportation hearings. They are walking away from guaranteed revenue because the public relations cost is too high. And the agricultural lobby, one of the most powerful Republican-aligned interest groups in the country, is threatening a federal lawsuit. The American Farm Bureau Federation released a statement saying this policy, quote, threatens the economic viability of American agriculture and violates established guest worker program protections. Here are the numbers you need to understand. 147 Fortune 500 CEOs signed a joint statement calling this policy economically destabilizing. Not Minnesota companies, not California tech firms, companies from every state, including deep red states. $3.2 billion in federal contracts are now at risk because companies are refusing to participate in enforcement operations. And the stock market dropped 847 points on Tuesday on what analysts called policy uncertainty. When you lose the money, guys, you lose the Republicans who actually matter. Now, let me tell you about the states, because what is happening at the state level is not just political posturing. This is a constitutional standoff. California, New York, Illinois, Massachusetts have all passed emergency orders instructing state police to not cooperate with ICE under any circumstances. State attorneys general are preparing lawsuits under the 10th Amendment, arguing this violates state sovereignty. But here is what is remarkable. Red state governors are breaking too. Utah Governor Spencer Cox said on camera yesterday, quote, this policy violates state sovereignty and puts our communities at risk. We will not be complicit. Georgia. Governor Brian Kemp is quietly instructing state agencies to stonewall federal requests for assistance. No public statements, just quiet bureaucratic resistance. And Texas. Lieutenant Governor Dan Patrick, one of the most conservative officials in the country, called this federal overreach. When Texas starts talking about federal overreach on immigration, you know something has broken. But one state is drafting something unprecedented, something that could trigger a genuine constitutional crisis. I will tell you which state and what they are planning in just a moment. Stay with me. Here is the crisis everybody is missing. ICE cannot actually enforce immigration law without state and local cooperation. Let me explain the operational reality. Immigration and Customs Enforcement has approximately 6,000 field agents nationwide. 6,000 agents to cover 330 million people across 3.8 million square miles. The only way that math works is if state and local law enforcement agencies cooperate. They hold people in custody. They notify ICE of arrests. They share database access. They provide manpower for raids. Without that cooperation, the federal government simply cannot function. 70% of ICE enforcement capacity depends on state and local partnerships. 70%. And right now, 19 states representing 163 million Americans have cut off cooperation completely. The math is brutal. To enforce immigration law without state help, ICE would need approximately 60,000 agents. Congress will not fund that expansion. The appropriations do not exist. The infrastructure does not exist. And the Posse Comitatus Act prohibits using military forces for domestic law enforcement. So the Trump administration just picked a fight it cannot win operationally. The only way forward is further escalation, and that is what makes this so dangerous. Now let me tell you about California, the state I mentioned. Here is what they are drafting right now. A state law that would criminalize cooperation with federal immigration enforcement, not just prohibit it, criminalize it. Any state or local official who assists ICE in any way would face removal from office and criminal penalties up to 3 years in state prison. The bill also creates something called sanctuary officer protection. Whistleblowers who report cooperation with ICE would receive legal immunity and financial rewards funded by the state. This is a direct challenge to the Supremacy Clause of the United States Constitution. Article 6. Federal law is supposed to be supreme over state law. California is saying, no, not this time, not this law. If California passes this and the state legislature has the votes to do it by next week, we are in genuine constitutional crisis territory. The federal government would have two options: back down and admit it cannot enforce its own laws in the largest state in the union, or try to arrest California officials for enforcing California law. Neither option ends well. Let me give you the historical parallel. 1832, South Carolina nullification crisis. South Carolina declared federal tariff laws null and void within its borders. President Andrew Jackson threatened to send federal troops. South Carolina threatened armed resistance. The crisis came within days of military confrontation between federal forces and state militia. It was only resolved because both sides backed down at the last possible moment. Compromise tariff. South Carolina rescinded nullification. Disaster averted. But here's the question: who blinks first this time? Does Trump back down? Does California back down? Or do we actually see federal agents trying to arrest state officials while state police try to arrest federal agents? I am not being hyperbolic. Legal scholars are already gaming this out, and nobody has a good answer. Now let me tell you what is happening internationally, because the rest of the world is watching this. The United Nations Human Rights Council called an emergency session for Friday. NATO allies are issuing diplomatic statements of concern. That is code for "we are alarmed but trying to be polite." Canada is preparing for a refugee surge at the northern border. Canadian immigration officials are setting up processing centers in border towns. And Mexico is threatening trade retaliation. The Mexican government said yesterday that if mass deportations begin, they will reconsider cooperation on border security and drug interdiction. Here is what this means. When America lectures other countries about human rights, about the rule of law, about democratic norms, they will just point to this. Our moral authority, already damaged over the last decade, is being permanently shredded. That soft power, that ability to lead by example, is the foundation of American influence globally, and it is collapsing in real time. Let me walk you through what happens in the next 30 days. I'm going to give you 3 scenarios with realistic probability estimates based on what legal experts and political analysts are telling me right now. Scenario 1, judicial intervention, probability 40%. The Supreme Court takes an emergency petition from one of the state attorneys general. They issue a nationwide injunction blocking expedited removal. The administration partially complies while appealing. The crisis de-escalates, but the precedent has been set. Future administrations now know they can try this. The guardrails held this time, but they are weaker now. Scenario 2, political collapse, probability 35%. Congressional Republicans break en masse. Moderate Republicans in swing districts face constituent pressure they cannot ignore. The funding bill for Department of Homeland Security fails in the House. Without funding, enforcement operations have to scale back. Trump declares victory anyway, claims he deported more people than any president in history, and moves on to the next crisis. This is the best-case scenario. It requires Republicans to actually stand up. That is why the probability is only 35%. Scenario 3, constitutional crisis, probability 25%. California passes its criminal enforcement ban. Federal agents try to operate anyway. State police arrest federal agents, or federal agents arrest state officials. Trump invokes the Insurrection Act. He orders military forces to California to enforce federal law. And here is where it gets truly terrifying. What if the military refuses? What if generals conclude the order is unlawful? We are talking about genuine breakdown of the federal system. That 25% should scare you. 3 weeks ago, could you imagine Republican governors threatening to block federal agents? Yet here we are. Here is why this time is different. 2017 through 2020, Trump tested boundaries and institutions held, but Trump learned from those failures. He is not making the same mistakes. This time, he is targeting the legal infrastructure itself, the courts, the procedures, the review mechanisms, and the people who said no last time are gone. There is no John Kelly, no James Mattis, no Rex Tillerson. The adults in the room have been systematically purged. 47 Trump-appointed judges are still on the bench. Department of Justice leadership is all loyalists. The career civil servants who leaked, who resisted, who slow-walked have been fired. So let me bring you back to that memo. Prioritize speed over procedural compliance. This is not just about immigration. This is a template for governing. Emergency powers normalized. Due process treated as optional. Courts viewed as obstacles, not as a co-equal branch of government. This is not about border security. It never was. This is about whether we still have a government of laws or whether we now have a government of one man's will. That is the question. And we are about to get an answer. Let me summarize where we are right now. A leaked memo orders federal agents to ignore legal procedures. Republican judges and lawyers are breaking ranks in unprecedented numbers. States are preparing constitutional confrontation. The business community is actively sabotaging enforcement operations. International credibility is collapsing. 3 scenarios ahead, none of them good. And we are in a 72-hour window before the next major escalation. Here is the question nobody in power wants to say out loud. What do you do when the president orders something unconstitutional and 40% of the country thinks he should do it anyway? Think about that. The courts can issue orders, but they need federal marshals to enforce those orders. The marshals report to the president. Congress can pass laws, but they need the executive branch to implement those laws. Impeachment requires 67 votes in the Senate. That is impossible with the current composition. And elections are 20 months away. The system was designed for someone who wants to follow the rules. What happens when someone simply does not? Let me tell you why you personally need to pay attention to this. If you are an immigrant, documented or undocumented, this is a direct threat to your safety and your family's safety. If you are a United States citizen, this sets a precedent that your constitutional rights are conditional, that due process is optional, that speed matters more than legality. If you run a business, you are looking at legal chaos and economic instability that will affect supply chains, labor markets, and consumer confidence. If you care about America's role in the world, you are watching permanent damage to our ability to lead by example. So what can you do? Let me be realistic with you. I am not going to tell you that protest alone will fix this. Here is what you can actually do right now. Document everything. If you witness ICE encounters, film them. Save screenshots of social media posts that get deleted. Create a record. Support legal defense funds. The ACLU, immigrant rights organizations, they are filing the lawsuits that might stop this. They need resources. Contact your representatives, especially if they are Republican. They need to hear from constituents that this is unacceptable. Pressure businesses to take public stands. Boycotts work when they are organized and sustained. Long-term, educate yourself on what is actually in the law. ICE has limits that most people do not know about. Build community defense networks. Know your rights workshops. Legal observer training. Prepare for escalation because it is coming. I cannot promise you that any of this will work. What I can promise you is that silence guarantees you lose. Subscribe to this channel right now. Click the notification bell. In the next 72 hours, one of three things will happen. The courts will intervene, Congress will break, or we enter constitutional crisis. When it happens, I will break it down the moment the news drops. You will understand the legal mechanics. You will see the institutional implications. You will not be caught off guard. Like this video, share it with everyone you know, drop a comment with your state. I want to know where this analysis is reaching. And one more thing, there is a piece of this story I could not fit into this video. It involves a classified briefing that 3 senators walked out of last week. Nobody is reporting on it. I am covering it in the next video. Watch it now. The link is on your screen. Stay alert, stay informed. I will see you in the next breakdown.